Hello, everyone. This is Michael Miscoe of Miscoe Health Law with, on behalf of ChiroSecure for this week's Facebook Live presentation with what I hope will be another riveting
Hello, everyone.
compliance
This is
topic.
Michael
I
Miscoe
understand
of
the
Miscoe
riveting
Health
and
Law with,
compliance topics are usually oxymorons, but today we're going to talk about multidisciplinary practice risks. When you think about multidisciplinary practice, many providers are being approached or know providers that are in multidisciplinary practice, and they seem to be doing well. And they approach it from a hopefully for the benefit of the patient to offer services that they can't offer within the scope of their chiropractic license. But let's be fair, there's always a financial motive involved. It's important as you approach this to understand that there are significant compliance risks. This doesn't mean that I'm suggesting that you shouldn't get involved in a multidisciplinary practice, but you need to know what risks you're taking on going in. And the first thing that you have to understand, if your multidisciplinary practice is going to bill third-party payers, especially Medicare, is that the government and most commercial payer SIU units, their fundamental perception of a chiropractically owned, controlled, managed multidisciplinary practice is that it is a criminal enterprise. And that's their fundamental perception. And the reason is going back to some of the more notable convictions, I won't mention any names, but going back more than 10 years, there have been some significant criminal issues as well as healthcare fraud, False Claims Act issues brought against multidisciplinary practices for what I consider fundamental compliance mistakes, not recognizing the risks that they're taking in engaging in this type of practice. Understand that a medically owned multidisciplinary practice, let's say I have a client who's an orthopedic practice, they do spine, knees, a variety of orthopedic types of surgery, rather large practice. They've hired a chiropractor, they offer conservative care in-house. They also hire PTs, and all of the compliance risks that I would normally attribute to a chiropractically owned or managed multidisciplinary practice go away because the medical doctors are actually in control of the practice. In a chiropractically owned practice, and the corporate practice and medicine laws vary from state to state in terms of whether the chiropractor can own any of it, if so, how much they can own and what the share distribution is. One of the most significant problems is that the medical doctor the government determines is what they call a sham owner. They're granted their stock, they have no buy-in, they're not a real owner, they don't get K1 distributions at the end of the year. So they're pretty much an employed medical doctor. Sometimes they're a medical director only. They don't actually come to the practice except occasionally, or as often as they need to establish supervision over the mid-levels. And all the care is rendered through mid-levels, which, is fine. But when you're a medical director, you're sharing it with a number of other multidisciplinary practices, that's easy for a payer to ascertain or the government to ascertain. And they recognize that your medical doctor owner is more or less a placeholder to permit the performance of medical care in what is essentially a chiropractic office. And that leads to some problems that we'll discuss. So understanding that perception, there's a couple of things that you can do, to convince the government that you're not like that. Okay. One, have a real medical doctor owner, a partner that's going to share costs, share risk, share profit. Absent that, what most of these structures do is they set up a legitimate medical corporation with legitimate medical doctor ownership, at least on paper. And then they set up a collateral management company. And then rather than execute fair market value contracts for the services that the management company's actually going to provide, equipment that it's actually going to lease, and it's a fixed expense regardless of volume or value, what essentially the management corporation does is its fee each month is essentially the profit. So after the medical corporation pays the medical doctor and any other fixed expenses that it has, then the rest of the profit is swept out as a management fee which is not fair market value. Number one, it's not a management fee that you would pay to another management company in what we call an arm's length transaction. And therefore, the government looks at it as money laundering. And I'll explain how that ties in with their fundamental fraud theories relative to these corporations. So step number one, find a medical doctor that you want to partner with, and establish that as an actual business venture that is multidisciplinary. And that is the easiest way to deflate some of the risk. Second thing is that the medical doctors have to control medical care. I see in pain management, multidisciplinary practices, protocols of injections that you would never see in any pain management practice that was run medically. These protocols are derived for one thing and one thing only, predominantly to make a lot of money. And unfortunately, I call them pincushion protocols because the patient comes in, they're getting tendon sheath injections, trigger point injections, facet injections, major joint injections, and they're spacing them out, playing jumping areas. This month we're doing this knee, next month we're doing that knee, and they move around, and the patient gets a consistent series of injections, which generates a lot of income. Unfortunately, it also generates a very abnormal profile, which will start a payer looking at your entity. The other mistake that a lot of multidisciplinary practices make is they will do medical and conservative care, whether it be chiropractic or PT, on the same day. And chiropractic and medical especially is problematic. My advice is that if you're going to offer chiropractic services within that entity, meaning the entity is going to employ the chiropractor, and you're going to provide chiropractic services, and that structure eliminates a lot of the Stark-Indian kickback problems relative to referrals from a chiropractic entity to a medical entity that the chiropractor has a direct or indirect interest in. Those go away when it's all in-house, but treat the patient conservatively, get whatever benefit you're going to get, and if the recovery is incomplete, then you refer them to medical and you stay away from that patient. And the reason is because the most common fraud theory that brings down multidisciplinary entities, and usually the chiropractor, because the chiropractor is the big cheese usually in these cases, is what they call fraudulent identification of the provider of service. You bill the services medically under an NP or an MD, whoever's there, but in reality, the government argues, and they've argued this successfully, the chiropractor is really in control of the care. When they put the arm on your medical staff, whether it's a nurse practitioner, a medical doctor, DL, whatever it is, physician assistant, they're going to flip and they're going to say, hey, I just did what Dr. So-and-so told me to do. And some people, you have angry ex-medical staff that were uncomfortable with the structure, and that's what leads to the investigation. Sometimes it's the billing profile, but that generates enormous amount of risk. And essentially what the government argues is that the chiropractor was controlling medical care, which he wasn't licensed to do. They misrepresented who was controlling the care on the claim form to get it paid, meaning you were billing under a medical provider. And that's the only reason the government or the payer paid it. And as a result, all the money goes back, and that's the fraud theory. Then they'll toss in money laundering if you have this management situation going on at the same time. And if it's Medicare, they have an enormous amount of power. Let's assume you're doing everything perfectly. They're going to flip your medical doctor anyway because they're going to threaten them with exclusion, which means that medical doctor's medical career is over because most medical doctors don't have the option to run a cash practice. The misrepresentation theory is especially problematic, and it's been a winner consistently. Only because, the protocols aren't medically sourced. The medical doctor, regardless of what's really going on, you have structure, you have agreements that they're entirely responsible for medical care. And all of that stuff existed in every case where a chiropractor was prosecuted under a fraud theory, under this provider misidentification approach. The other thing that creates a lot of risk for multidisciplinary practices, and unfortunately there are some consultants out there, you need to read these contracts very carefully. If they say they're not responsible for anything that you bill and you're entirely responsible and they're laying all the risk on you, then I wouldn't give a lot of credibility to what they're telling you. There have been a number of things, ALCAT testing, P-stims, ANSYS, these electroacupuncture devices, and any number of other things that have brought practices, bankrupted them. I mean, it's an end of practice event because of the amount of money that it generated and the amount of time. Payers pick up on it. They come in, they want it all back. I've seen lab-related services, like, for example, I had a number of clients out in California where they were advised to do this lab testing thing. They were upcharging on the lab service, which is illegal under the Medical Practice Act. And, they were given the opportunity to just pay back the amount of the overpayment. Those that did, they were fine. Those that didn't, the medical doctor was prosecuted, flipped on the chiropractor, and then it ended up being a criminal situation for the chiropractors involved. And once you get down that road, there's no walking it back. Other things like stem cells, where they're trying to bill Medicare for this stuff, those are statutorily not covered because they're not FDA approved. I know some represent that they are, but they're not. They have FDA, what's called Section 361 or 351 registration, which is not an approval for marketing for a particular use. There have been some that have been approved for wound care, and I've seen all kind of crazy theories that injections inside of knees is really a wound, and it's not true. So, I mean, multidisciplinary practice is much safer on the cash side. I mean, you can do all this stuff for cash. You just have to be cautious with your marketing so that you don't get challenged by your state licensure board for deceptive marketing. But the key to it is make sure you understand what you're doing and get independent advice from somebody that's willing to back it up with appropriate research of the relevant statutes, regulations, medical policies, whatever it is, your provider contracts, to make sure that you're doing this stuff correctly. And then even running a multidisciplinary practice entirely legal, there's certain things like co-management that you won't do, not because it's illegal, but because it doesn't make sense. And the reason it doesn't make sense, if you're treating a patient conservatively, it has to be because you have an expectation that it's going to work. But then collaterally, you're treating the patient medically, which is premised on the fact that conservative care was ineffective. So you have two treatment plans beaten against each other. Same thing with mixing chiro and PT at the same time, because they're separate treatment plans ostensibly to achieve the same result, in which case, under what's called the most cost-effective, least costly setting component of most medical necessity policies, if one's going to work according to its treatment plan, then I don't need the other one. And then they'll pick the cheaper one and ask you to pay back the more expensive one. Multiple E&Ms on the same visit. I mean, those, they're technically permissible, but they don't make a lot of sense. And yes, there are exceptions for when a chiropractor is evaluating a completely separate and distinct problem from the medical doctor. But in most cases, multidisciplinary practices are not set up for the medical doctor is going to do family care like primary medicine, and the chiropractor is going to do traditional neuromusculoskeletal care. Usually they're into the same pot, in which case there's overlap in the conditions, and that causes a data profile or a billing profile that makes you a target. Once they start looking, in a lot of cases, the best you can hope for is that you only have to pay the money back. Went a little long today, but to conclude, if you're looking at that, call me, call somebody that has no vested interest one way or another, and get them to evaluate what you want to do, walk through the risks for you, and I'll leave you with this thought process. Most chiropractors get in multidisciplinary practice scenarios have to choose between continuing to practice or running a business. Because when you get into that, managing the compliance risk, making sure that the medical staff are doing their documentation appropriately and they're not setting you up for post-payment liability on that front. There's no upcoding going on, all this other stuff, managing your contracts. You're going to become a business manager. And if that's not your cup of tea, you might look at another way to make money. If you're getting involved in this and you're going to keep it cash, that's a lot safer, easier to manage, and you pretty much just have to watch your marketing. So get help, and use consultants, sure, but when they're disclaiming any obligation for what they're telling you, you better get an independent analysis, and be very, very cautious about things that pay a lot of money, because those are the first things that you're going to get challenged on and probably have to refund. So make sure you recalibrate your "it's too good to be true" alarm before you go tripping the light fantastic into what is a very, very dangerous and risky practice model that could turn out not so fun down the road. That's all we have time for today. Thanks for your attention, and we'll see you next time.